Hello and welcome to another of our short presentations on mediation. This one is concentrating on what happens at a mediation for those of you. And what we're going to cover are the possible stages. There are 5 of them. We're going to focus on the 3 main stages that we recommend and look at the contents and objectives of each. And then we're going to look at the whole area of preparation and how you can prepare for yourself to get the best out of a mediation, but also how you could prepare information that could be shared before the mediation starts. So I said there were 5 possible stages. The first is entirely optional. If you have appointed legal advisors, it might be useful for the mediators to meet with them together to understand what negotiations or discussions have already taken place, to identify any legal issues, to see whether or not any solutions have already been explored, to identify whether a compromise agreement is needed, that's a full and final settlement, and to discuss practical issues such as the mediation dates, whether or not their offices would be acceptable as a venue and that sort of thing. The second stage, which is highly recommended for those of you who've not been involved in a mediation before, is a pre-mediation meeting. It's a private meeting with you and your advisors to answer any questions you've got on the process, to discuss the dispute as you see it, and any ideal outcomes that you may have. This creates an informed commitment from everyone involved, and that's very important for us. It's also an opportunity for us to look with you at preparation before the main meeting. The third stage, fairly obviously, is the main mediation itself. That's usually a day of discussions held in joint and private sessions, and we'll cover more of that later. But it is entirely possible that it might be a series of half days because that's more appropriate for people's diaries. The fourth stage, which we recommend if the mediation looks as though it's going to take some time on the main day, is a half-day sign-off meeting, which can be held a few days after the main meeting. And it's useful for 2 or 3 reasons. First of all, it reduces pressure to settle when you could be tired at the end of a day and there might be quite a complex agreement on the table. It also allows you to check solutions for their viability. For example, if another organization or another member of your organization or another individual needs to be involved, for example, somebody needs to pay for additional training, or if you have an advisor, for example, an accountant, who might need to give you advice on tax implications of one of the solutions, then you get time to do that before you sign off the final document. And the 5th stage, which is entirely optional, not everybody needs it, is the option of calling on the mediator to a meeting in a few weeks, a few months, to meet up with both parties, to check on the progress, to see if there are elements of the resolution which are not working quite as you thought they might, and for the mediator to sit with the 2 of you and to help you work out again how you might resolve that issue, given that your relationship might still be a bit strained. Look then at the 3 main ones: pre-mediation, mediation, and the sign-off meeting in more detail. Starting with the pre-mediation meeting, it is important to remind people that it is strictly private and confidential. What goes on in that meeting, whether your advisors are there or not, which is entirely your decision, but what goes on in that meeting is never repeated to anybody else outside that meeting unless you specifically agree to it. From our perspective, it's important that we're able to allay any fears that you have and to gain commitment to the process. Therefore, we're looking to be able to answer any questions that you may ask us so that you can reach an informed decision. And we may start with a really open-ended question such as, what would you like to know about the process of mediation? And you can ask anything you want. We hopefully will give you an understanding of the process and its potential benefits, and therefore a commitment to it. But we will also listen to your story about the conflict, about the dispute. And just to remind everybody, We are independent, we are objective, we are non-judgmental listeners, and we may be the first person who's actually done that for some time. And we may ask a simple question to begin with: can you tell me what you think this is all about? In that conversation, we will then seek to help you to identify what your most important issues are, those which you absolutely have to have discussed and resolved at the mediation. We'll also try to help you to identify what you would like an ideal outcome to be from the mediation. And once we've gone through all of that, we can then start the organisation itself, looking at dates, locations, who should be there, what advisors, and any other detail that's important. And we can begin to discuss preparation for that meeting. Looking at that in more detail, the primary objective of preparation is to help you to gather your thoughts. What do you think happened? What outcomes are in your best interests? What is really important for you for the future against what you may say that you actually want? What would your best and worst outcomes be? Understand and think through the negotiating parameters that you've got when you go into this mediation. Think through the same thing for the other party. What could you do for them? What could you give them in order that they give you something that you want? There are also documents that can be produced which could be shared before the mediation, and there are two in particular. The first is an issues agenda. If you have thought through the key issues that you must have resolved, you could put them down on paper, get them to the mediator. The mediator will do the same with the other party and combine the agendas and share them before the mediation. So everybody can see that their issues will be discussed because they're on the agenda, but you will also gain an insight into those issues that are common and those which are not. And you may be surprised at what's on that list. There may be issues written down by the other party that you had no idea were important to them, and that's valuable information. The second document is a timeline. That's a time plan of the key stages leading up to and after the dispute, noting the key issues that arose at each stage. That can also be helpful. And again, what you may find is that the other party's view about what happened and when and what was most important at each stage don't match yours. So you will gain an insight into their thinking and they will gain an insight into yours. And again, you will enter the mediation with a lot more information than you had before you started. What then about the main mediation? You will have arrived at a location and at a time that you've all agreed to, and the mediators will have met you and taken you to your private room and settled you in with a calming cup of tea or coffee and a pastry and asked any last-minute questions. And then at a pre-agreed time they'll bring you into a joint meeting room. And because you are now in a room with someone with whom you are in conflict and you may not have seen them for some time, everybody's going to be nervous, and that's fine. So the mediators will start to reduce that nervousness, and they'll do it by welcoming everybody, by checking the use of first names, by detailing any housekeeping issues such as fire alarms, where the loos are, that sort of thing. They will acknowledge the disruption that is caused by conflict. They'll acknowledge both the effect on you as an individual and also on your organisation, and they will talk about the success rate of mediation. On average, 75 to 80% of mediations work, and the definition of work is that the parties agree a set of solutions which are followed through. So the definition of work, the definition of success is not ours. It's the people involved in the mediation. Having done that, the mediators will then probably move on to discuss their role and the benefits of mediation, to remind everybody that they're there to chair, to facilitate the discussions, that they're neutral, they're impartial, they're not there to advise, they're not there to judge you, they're also not involved in the detail. Therefore they can stand back, they can help to bring clarity to the key issues in your discussion, they can help you see the wood for the trees. They can even help you see the landscape in which the wood sits. They'll talk about the benefits of mediation. An important one, it's voluntary. If the mediation discussions are going nowhere, you could get up and leave. There's absolutely no holding you back if you wish to do that. Another benefit is it's allowing you face-to-face communication with someone you may not have seen for some months, and that enables you to create an understanding of the motivations and the interests that the other party has. And they get the same understanding about you. And with that understanding, you are then in a position to determine yourselves how to resolve the issues that you've raised in your best interests. No third party is going to tell you what to do. No third party is going to tell you you can't do what the two of you have agreed you want to do. They'll talk about the format for the day, that you would be on the whole kept together in these discussions while they're proving constructive. They'll make a plea for minimal interruptions because interruptions become frustrating. They'll remind everybody that you can call time out whenever you want to, and they'll remind you that your private rooms are there for you to consider the key points, to think about proposals that you might want to make to the other side, or just to have a quiet moment to relax. And they'll talk about the outcomes from the day, that you're there to negotiate to solve problems, that you're there to try to get on with your normal lives, that although it may appear to be a long day, other dates are available, and they'll check again with timing issues, and that's a direct reference to the final stage, the fourth stage rather, which is the sign-off meeting. And they'll probably close with two important points. Confidentiality, to remind you of what was said at the pre-mediation meetings, that the mediation itself is confidential, that private meetings are entirely confidential. What you say to a mediator in a private meeting stays in that private meeting, and that only with your permission can anything like that be shared. And they'll mention an issue called without prejudice, and what that means is that while you're thinking of options, you can test ideas, you can road test ideas with the other side without the fear of being bound to them or held to them. The only time that you will be held to them is when you've both agreed them and they're signed and they're written up in a signed document, your settlement agreement. So the mediator's taken probably 5 to 10 minutes to do that. He will have asked the two of you whether you would like to make your opening statements once the mediators have finished, and one of you will have agreed that you want to do that. And so the morning starts, and it starts with your 5 to 10 minute summary of your understanding of the dispute and what you hope the mediation will achieve, and it's done without interruption, so everyone has been heard. And you may find that you hear something you hadn't expected. And the mediator, at the end of your opening statements, will ask if anyone would like to respond to anything they've just heard, or whether you'd prefer to start with an issues agenda if one's been agreed. And they will ensure that the main issues are agreed and confirmed, and that time is then given to unpick them, to look at each one in some detail. And you'll probably find that the discussion will start without much prompting. The mediator may say little. They may suggest that they flip chart the key issues as a common agenda, which is quite useful. They'll allow stories of past behaviours and actions as useful examples of key issues, but if they become points where you're picking over them endlessly, they may well curtail that conversation because it's not being productive, it's not being constructive. And if you need time in your private room to consider information you've heard and how it affects your view of the dispute and your position or your attitude towards the other party, fine. Remember, you can call that at any time. But that period will allow you to exchange information and expand your knowledge so that you're in a better position to judge what sort of resolution. So towards lunchtime or the early afternoon, the mediator is going to suggest that you switch your focus from looking at the past to looking at the present and the future. And to do that, you're moving into the solution generation phase. And the likelihood is, if you've got these flip charted, that the mediators will ask which issue you'd like to start developing detailed options for. And if you've got, for example, 6 key issues and you've unpicked each one in some detail, there is liable to be a group of 4 of them that are not that difficult, where you're not that far apart. But there's also liable to be 1 or 2 which are going to be really quite difficult. And therefore, for the easier issues, the mediators are liable to suggest that you can develop the options in a joint meeting, with the mediator asking questions about each. How does it work? Who does it? When's it going to happen? All those sorts of detailed things to ensure that it will work, not because they will be criticizing your ideas or judging or anything like that. And what you may find at the end of that process is you've actually started working with this person with whom you're in dispute. You've realized that there are ways in which you can create outcomes which are to your mutual benefit. And that's really useful when you move on to the harder issues. And here, the mediator may suggest that you talk through each one together in a joint session and identify broad options, and then perhaps retire to your private rooms to think through the details, and perhaps use the mediator to take ideas to the other side to test the waters, this idea of without prejudice. Now, towards the late afternoon, if you have lawyers advising you, the mediator may suggest that they go off and start to put together a draft settlement agreement. If you don't have advisors present, lawyers present, the mediator may suggest that they do it. And what the mediators are liable to do while that draft is being prepared is to look with you at either a particular issue that you may be having difficulty with, or to start you thinking about how to avoid the same thing happening again, that what have we learned conversation. If your relationship could continue, and if possible conflicts could arise in the future, what have you learned today that would help you to stop those potential conflicts becoming conflicts in the future? And then, as the settlement agreement begins to take its final shape, you will want to take calm time to sit on your own or to sit with the mediator and to go through some of the basic questions about whether or not the procedures, the actions that you've outlined in the agreement are actually going to work. And that will be a final time towards the end of the day when you may decide that what you want to do is not make decisions at this point. To the third stage that we talked about, which was a sign-off meeting. If you have a settlement or compromise agreement, it may run to many pages, and they are not, frankly, best reviewed by tired eyes and minds. If you agree a sign-off meeting, and you may decide that you need it because you need to confer with other people, perhaps there's tax advice that you need to think about, You may need to talk to somebody about whether or not training can be provided, or someone else who can affect the resolution item that you've agreed with the other party. If a sign-off meeting is important and agreed, the mediator will remind you of the confidential nature of the agreement, and if other people need to be contacted, who they're going to be and what information they will receive. Are you going to send them the draft settlement agreement? Are they to have sight of everything? So again, it's part confidentiality, it's your control. You are the people who are able to determine all of this. And finally, for the sign-off meeting, the mediator again will get nitpicky about the date. When's it going to happen? Who's going to be present? Are some of the new advisors, for example the accountants, to be present at that meeting where they weren't before? So, in summary, in the last 20 minutes we've looked at the possible stages in a mediation. We've concentrated in more detail on the contents and objectives of 3 key meetings. And we've looked at how you can prepare to get your own thoughts in order and also prepare information to share before the main meeting in order that you can, to a certain extent, hit the ground running. There's more information on this whole topic as a downloadable PDF on the website, but if you have any questions, please use the 0845 number or my mobile number, or indeed use the email address that's on this presentation and is on our website to ask any questions that you need to, remembering that those conversations themselves will be in strict confidence. I hope to talk to you soon. Thank you very much indeed for listening.